Hello, everybody. Hope you're having a great Thursday so far. My name is Natasha Phipps with Phipps Real Estate Group here in Calgary, Alberta, and CIR Realty. I am a real estate investor, a investment specialist realtor, and we like to do these events to bring you some value, some education, also, so we can learn from one another. So today's no different. Today we are bringing in one of our industry experts. And I'm joined today by Scott Bollinger of Bollinger Associates. He's a top lawyer here in Calgary and specializes in working with investors. So thank you so much for being here today, Scott.
Thanks for having me, Natasha. Looking forward to our discussion.
Yeah. So first off, tell us about you, and you're well known as a specialist in the investment space, but tell us a little bit about kind of how you got started and your background.
Yeah, sure. So I kind of fell into real estate back in 2005, 2006. So
Okay.
if you're old enough to remember that, you remember that's the time when it was going crazy in Calgary. And so I'd just come out of school at that point, and it was like you look around and it's like, wow, you can't help but make money in real estate, and this seems exciting. So anyway, I ended up with a real estate license and started in commercial real estate, and then sort of shifted over to residential real estate over a couple of years. And so I had my residential, I had my real estate license from 2006 and right through for about a decade, and did various things, including running my own brokerage and then managing realtors, as well as had my I had a mortgage license and
Wow.
and actually started a mortgage investment corporation just before, again, the crash in 2007-8, which the crash wasn't exactly relevant, but the purview of the Securities Commission was at the time, because the mortgage investment corporations were a great vehicle for small investors and managers to get going with syndicated mortgages, but that was prior to the Securities Commission actually coming through and revising the legislation to include mortgage investment corporations under that legislation. So in other words, it made it much more difficult to administer, and it required you to be a much bigger fund in order to really make a go of it at that time. So anyway, all of that to say, I have some experience with lending as well, and then I had my license and ultimately went back to law school a little later in my 30s and focused on real estate law, and here I am. I've been doing my own thing for about 3 years now in real estate law, and I just love it. Yeah.
That is an incredible background. Like that, you've done like three main sectors of really real estate investing that people need to work with. They need their investment focused mortgage broker, their investment focused realtor, as well as their lawyer to be on board with everything that they're doing and advising them in the right way. Like that is a very unique skill set. And it's obvious when we have these kind of conversations. I've had a few chats with you about this over the years, and your insight is super valuable. So today you operate as a real estate law firm, or do you do other law, or is it real estate focused?
Yeah, we're real estate focused. It's a boutique shop that I've got here. It's really just a couple of us, and we're real estate focused. And I mean, that's just honestly the way you want it to be with most lawyers. You want to have them specialized, just like anybody else in any profession.
100%. Yeah, 100%. Find the person that's doing that job, right? And find the best one for it. Awesome.
That's right. Yeah.
That's great. We have done many transactions together, and we'll do many more, I'm sure. So what I wanted to kind of talk on today was creative deal making. And people end up here for a multitude of reasons trying to explore creative deal making. And the first challenge people have actually is finding lawyers to get on board with creative deal making. What do you kind of say to that, just like at high level? Because it can be a challenge.
Mm-hmm. Yeah, that is a good question. I've actually wondered it myself, because it seems like there are not a lot of lawyers out there that are willing to either. I think a lot of them are simply busy, right? They have established practices and they've been doing certain things, and so they just don't want to spend the time on this particular, because it does the creative deals tend to take some more time, and they take on a little bit more risk as well for the lawyer and the client and everything else. Another thing is I really do think that having a background in real estate helps me to to be familiar with these tools and to be comfortable with them, with
Yeah.
these out of the box types of tools. So, and it's not to, I would, if I went from school, coming out of my BA and going right into going into law school and then coming out and then, just working within a larger firm or a mid-sized firm, even, they don't
Sure.
get the kind of exposure. They get a lot of great exposure for other files, but they don't get the kind of
Yeah.
exposure that I would have ultimately gotten through my, my travels. And I think that just, what makes me more comfortable with that type of thing.
That's a really good point. Just like any profession, really, like if I think in the real estate course, when, for agreement for sale, for example, it's probably one line in the, literature of what you're going to learn. So you hear about it, it's a thing, but unless you're going out and actively learning it and employing it and getting involved, it's just not what you're focused on. So that is a good point with anything, with, any career, and lawyers are no different. So that is a really good point. And realtors, like I said, they can be a barrier to putting these deals together. Lawyers can be a barrier to putting these deals together. So as always, finding the best people for the job is really what we always promote. But how can someone best work with their lawyer? Like, is it like if you have an agreement for sale, for example, deal, what would the best process be if this is my first time doing this? I'm new to creative deal making. Are you my first call? Like, what should I be doing first?
Yeah, well, good question. I think, again, if you're new, if that's the premise that we're starting with, if you're new to this, yes, I think a call to me or somebody else who's familiar with it
Yes.
and is willing to give you 5 or 10 minutes of their time would be wise, right? To just to make sure that one, we're on the same page, or two, that I can give you some steps to start out, right? To some guidelines to start out. So for example, with an agreement for sale, you may know the concept, right? Which is essentially a seller financed long purchase contract. So you enter into this purchase contract, you don't pay all of the purchase price right up front, even though you get possession. And so then the seller effectively finances the balance owing over time. So how do you even start that? What kind of agreements would you have to put in place? And so I can at least introduce that to you in a step-by-step process by saying, okay, well, here's how you would negotiate in principle verbally, right? And then you would ultimately put it down on paper, and here's how, right? Here's how I would recommend putting it on paper, fairly simply.
Yeah.
And then from that from that stage, what happens next? Then we go to the closing process. What does that include? And so I can walk you through that process. So I think it's worth a 10-minute chat about that. And
Totally.
ultimately, it does take a little bit more time, because it may be once you've come to an agreement in principle, getting it on paper might require my review as well, just to make sure that everybody's keeping their interests protected. The other thing you need to know is, maybe if you are interacting with the seller, that they're going to need a lawyer, and you might want to start to inquire as to who else would be willing to take on that file as well for the
We
seller.
would need 2 lawyers.
That's right. Yeah.
Yeah.
Yeah. Almost. Yes. I think the short answer is yes. You want 2 lawyers. You want independent legal advice on both sides. And, I mean, theoretically, you don't have to. And I've seen transactions that proceed and come to complete, come to fruition and complete without any problems. But I also have seen those transactions that get into a bit of a dispute later on down the road. And although it's not the silver bullet, having independent legal advice on the front end will help both parties, in particular the buyer. If you're in the buyer's situation and the seller is disputing something in the contract or some understanding of the transaction,
Yes.
they can't rely, or at least they're less likely to be able to rely on the argument that they didn't understand or that they were taken advantage of. So you want to eliminate those 2 potential excuses, because there's a whole bunch of other issues that you still have to deal with. But if you can eliminate those 2 by simply, having the seller get independent legal advice on the front end, then I think you'll be better served in the long run.
Yeah, 100%.
Yeah.
And you said something there. You said, like the contract can be simple. Like, it doesn't need to be necessarily extremely complicated either, because you want both sides to understand and be clear what we're doing. So getting two lawyers, that's a great way to do that, making sure that it's clearly laid out in the paperwork, obviously. Now the lawyers, they can be, as long as they're in the same province, it's fine, right? They don't need to be in the same city, just in the same province, correct?
That's correct. That's correct. Yeah.
Okay. Because I've found that to be the case, because it's kind of hard to necessarily find two lawyers in the same city. So they can be in different cities. That's fine.
Yes.
And independent advice is always suggested, I think. Really ever. I always suggest that. Builders tend to give you free services, and I always still recommend to get your own, because things can still go wrong, things can go sideways, things can change. So that's really good advice. So high level agreement for sale, we kind of talked about that. Like you said, it's good for people who tend to have some sort of financial barriers for whatever reason. Maybe they can't come up with the full deposit amount a bank requires, or they can't qualify for traditional financing. So you're using the seller's potential mortgage that they already have in place to help you buy your next property.
That's right.
What are the risks of that? Like what would the risks be of an agreement for sale?
Okay, well, there's lots, but let's start with a few that come to mind. I mean, from the buyer's perspective, what is the risk? Because you're looking at it from a buyer and you say, well, how could I go wrong? Maybe I only have to put $5,000 or $10,000 down, and I effectively take ownership of the property. At least I do. I take control of the property, and I take a form of equitable ownership in the property. So, and then I'm also placed as the buyer. If I perform the contract, I'm placed in the position of a borrower. And the seller becomes the lender, right, in a court of law. Ultimately, if there's a dispute, so in other words, you have protections that are afforded to a borrower if they were using it as if they were borrowing from a mortgage lender, meaning that there's equity of redemption. In other words, like if you miss a payment, you're not simply going to lose all your money or forfeit all of your cash that you've put up. There is a process by which the seller has to go through to ultimately to foreclose on you. So all of that to say, seems pretty good, right, from a buyer's perspective. But but there is an issue. The main issue that comes to mind is one, it's a long-term agreement. So as opposed to a simple, conventional purchase transaction where you enter into an agreement. Within approximately 30 days, you've completed, paid the purchase price, and you both go your separate ways. There might have been a dispute in about whether the fridge was working when you actually took possession or whatever, but that sort of gets resolved or not, and then everybody goes their separate ways, and that's the end of it.
Exactly.
In an agreement for sale, you have to cooperate with this other party over a lengthy period of time. It could be 6 months to 3 years. I've seen up to 7 years. It can work, but you really have to be concerned about the unpredictabilities of time and people over time, right?
Things change.
Things change. Now, as the buyer, you're saying, well, I mean, again, what does the seller have to do under this contract aside from give me possession? Well, they do. They have to give you possession, and once you've got possession, you're in good control. But they do have to make sure that they're servicing their mortgage. Now you can do things to help to control that as well by setting up a joint account and making sure the payments are made. But I've seen where other parties have just simply, because under the agreement for sale, technically what you would be doing is paying the seller under your seller financing arrangement, and then the seller would be responsible for paying their mortgage in place.
Exactly. That's usually the first question I get asked is, well, what if the seller doesn't put the money on the mortgage?
Then you've got a problem. I mean, ultimately the seller is liable to you for that loss, but it's hard to enforce if the seller doesn't have any money or whatever. So what you want to do is try to mitigate that risk by simply making the payments directly yourself. And so, in most cases, you would set up a joint account with the seller and have the money for the property taxes, for the mortgage payments, for whatever condo fees, other expenses for the property, all flowing through that account, so that and that goes to the other point about higher administration costs, right? Both in time and potentially money, but mostly time. You have to keep track of these. You have to keep records of all of these payments. You have to make sure that you're, dealing with a bunch of things, like, for example, if insurance, you need to have insurance on the property. Who actually holds the policy? It's likely to be the seller, because the insurance company is likely to
Want it to be-
require
Yeah.
require it to be in their name because they're on title. So then, pay anyway. So there's lots of things to deal with, but it's all manageable. It's just extra work that you might not have on a clean,
Sure.
purchase. And so that's potentially a risk. But as we go back to the longer term cooperation, and I try to explain it like this: people are unpredictable over time. So if they're cooperating this year, it doesn't necessarily mean they're in the same position, both mentally or financially or whatever next year. And I mean,
Yes.
it's not a high risk, but it's a risk that you have to
Sure. Yeah.
consider in these
Absolutely.
types of transactions. So the other one that comes to mind is the if you're taking on a property with a mortgage on title, you're almost certainly putting the seller in breach of their due on sale clause by entering into this contract. Okay, so the standard terms and conditions of a regular mortgage would just say that when the seller disposes of any of his interest in the property, that would give the option to the lender to call the mortgage. So that doesn't necessarily, it's just an option. It doesn't mean that the lender will, but the argument from the lender's side, and I don't know if they would win this argument, but it's certainly something you probably don't want to fight about with the lender, is that if you enter into an agreement for sale, that would be a disposal of was part or all of the seller's interest in the land, and therefore it would be that would give them the option to call the mortgage. Do they find out about the agreement for sale, the lender? Probably not. If they do they call the mortgage? Probably not.
As long
however,
as you're getting paid and
that's right.
There's no red flags going off. Yeah, exactly.
That's right. So the risk is quite low, but it is there. So if they call the mortgage, they say, okay, now what happens? Well, that's where the buyer really has to be concerned about his or her equity, right, that she's put in. So let's say you put $20,000 into the property and now you're making payments over a year's time, and then the lender steps in and says, wait a minute, we don't like this arrangement. We want you to pay us out. And they say this to the seller. So let's say the balance owing is $300,000. The seller now has to come up with $300,000. The seller says, well, I can't do it. I've got to sell the property or get that. So then he comes back to the buyer and says, you've got to pay me out because I've got to close. Anyway, so what? Yeah, exactly. You've got to close essentially. So what's the risk there? Well, you've got to close early. So you should have a plan B in place. And it might be private money. It might, that's right.
Thank you.
Right. Yeah, there you go.
Sure.
So my long-winded answer, I should have just said that in the first place, but that's essentially what it is. Yeah.
Which you always need, right?
Mm-hmm,
You always need that plan B. And if you're going to agreement for sale, as an example, I mean, you should be figuring out how you're going to close at some point anyway, like whether it's 2 or 3 years, like you said, commonly, like you still need to have a plan to exit the property. Now you could potentially have, renovated the property and built enough equity now that you maybe have the equity you didn't have to begin with, but you still need that plan of how you're going to get there, and plan B of how to close, period, on pressure and short notice. Always know what that is and make sure you can live with it. It's probably going to be potentially private funds or whatever, just to get it done. But knowing what that is upfront, that's huge. And I really like your comment about the long-term relationship thing. Like that is huge, whether it's a joint venture or rent to own agreement or agreement for sale. Like you're forming a relationship with these people for a long period of time. So bear that in mind. You're going to be talking to them a lot and have that kind of back and forth. So I don't think that's maybe considered or talked enough about. So thank you for mentioning that. People often go, well, what's the difference between agreement for sale and seller financing? Like the seller giving you a vendor mortgage. What would the difference be?
Yeah, the difference, few differences, but the main difference is the title does not transfer. So what we're talking about is a distinction between agreement for sale and vendor take back financing, probably, right? So, and they both operate similarly, right? In effect, they tend to, get to the same goalpost, but they are different. And so agreement for sale, your seller's name remains on title.
Yes.
And usually, right, that makes the most sense when there's already a registration or mortgage in place. So in other words, the seller, there's no option for the seller to actually transfer the title to you and then register a mortgage in the seller's favor as vendor take back. where you see vendor take back financing is when the vendor has, or the seller has a clear title, no mortgage, right? And they are in a position to actually be the bank, irrespective of any other lender. So that's when, if you find somebody, and I was just talking to a client recently about one in Sylvan Lake, they found a seller with some land with no mortgage on title, and so they had approached her about a vendor take back mortgage, and of course she wasn't very comfortable with it, but because her name was coming off title, and that doesn't necessarily, if I was trying to explain it to you, I would say, well, I don't think you're taking any more of a risk, because yes, you're transferring title to the buyer, but you are registering your mortgage, and as long as you're in first position on that,
Just like a bank.
Yeah, absolutely. So
Yeah.
if they don't make their payments, you'll get the property back eventually. It does take some time and some costs, but you're entitled to all of those costs. And however, most people, from just maybe a more lay person's view, they are less, seems to me anyway, they're less comfortable with their name coming off of title in a vendor take. So in other words, the agreement for sale seems to them to be more appealing. Simply because they say, oh, my name remains on title. Yes, but the actual mechanics of it over in law probably aren't much different, because, as I said, the buyer gets placed in the position of a borrower, as though they were taking a mortgage. In other words, they have equity of redemption if the and the seller would have to probably go through the courts in order to force them out. Anyway, there's protections there. Having said all of that, I think it makes, from a buyer's perspective, it's easier to sell the agreement for sale, because they're saying seller remains on title.
Yeah, exactly. That's kind of the feedback I've got from people too, is the seller likes the comfort of remaining on title there for sure. And the buyer, usually they're concerned about where their money's going when they hand it over every month. So pros and cons to both for sure. So typically agreement for sale when there's mortgage in place, registered on title, whereas vendor take back more commonly is when it's a clear title, maybe no mortgage on the property.
That's right.
And can it work for any type of property, like whether this is just a residential house or a condo or even commercial potentially, or is there any limitations there to what we're talking about?
Yeah, actually, no, there's not really any limitations on the property type. We don't see them very often on commercial properties, but I don't know whether that's just a function of the common. It's just not common, but it's possible. It's simply and it's possible on condos for sure. But yes,
I really like the idea of that for land, with that's kind of getting wheels turning in my head because for this Sylvan Lake opportunity, because it can be hard to get just a regular mortgage on vacant land.
Right.
Banks tend to want a very high down payment on that to lower their debt load, so the ratios usually aren't very good. So that's an interesting way to pick up some land to maybe develop it for something else just in the short term, maybe that 1 to 2 years while you're developing something. So I like that idea for vacant land. Cool. Is that what that person was thinking? They were going to maybe build something? Cool.
Yeah, absolutely. Yeah. So I don't think they were going to get away with it, to be honest with you. The seller was a bit skeptical, but that was the conversation that I had with them.
Yeah, for sure. Okay. So we talked a little bit about like needing multiple lawyers. And usually what I've heard when these things fall apart is the two lawyers are not in agreement, or one lawyer, just doesn't kind of get on board with this. Do you speak to the other side potentially so you can get on the same page, or like, is there anything that we can do as investors to kind of try to, make sure everyone's on the same page? Or is it really just like, it's really difficult to mitigate once the other lawyers decided, no, we don't like agreement for sale, and we're not going to advise our client?
Yeah, I think if we have a lawyer who's just set on causing objections and does not like the deal, my experience is that lawyer is likely not going to take the file. Simple as that, right? So I have and I've had that before. The lawyer would just look at it and say, he said to his client or potential client, run. That was his advice, right? You've heard that too.
Yes.
Okay. So that was, he didn't want to take the file. I've had other lawyers in varying degrees in terms of how much we can come to an agreement, or how important we think some of the more the less critical details are.
Yeah.
But ultimately, yes, that's what happens. So here's the ideal scenario: is you would, as a buyer and seller, you would enter into a purchase contract, which outlines, sets out the important, the basic terms of the deal, right? So there would be, so that there is not any there isn't too much room for a lawyer to start using discretion and to argue, about the ambiguity of the clauses. So you want, and that's the important part, is that, so the main agreement that you're entering into is as specific as possible about the very important things. For example, if you want a power of attorney, right, to be granted by the seller in favor of the buyer, and where you want that how you want that power of attorney to be used, or those types of things. If that is set out already in your purchase contract in the schedule, there's no debate.
Okay.
There's no room for debate as between the lawyers once we get with those documents. And in my experience, they're reasonable. That's just the way it is. They look. But having said that, if it's not specific and it just references a power of attorney, well, now we're going to get a significant amount of debate from the seller's lawyer, who's protecting his client's interest versus my client, and ultimately the buyer tends to have to back down on that. So if there's not specific, so for example, if you want the original power of attorney to be held in your possession as the buyer, and you didn't specify that, you're not going to get it. You're just not going to get it, because it's very, it could be very important to the seller, and legally you don't have the right. So anyway, that's an example of how, it's important to make sure that you've got those critical elements set out specifically. And once you do, then the rest of it tends to flow. And yes, I'm in contact with the lawyer after, so we would get the purchase contract fully executed, just like on a normal conveyancing transaction, in an ideal scenario, of course. I mean, often we would review it before you execute it, but once it's executed, then it's just a matter of, okay, well, here now we have to find out how we can make this transaction unfold as per this contract.
Yeah. Okay.
Yeah.
Great advice. So much there. And if I was a buyer, would you, and I didn't know another lawyer in Alberta, maybe I had a party and I could help them at least pick another lawyer, would calling you and asking for some recommendations, would that be okay?
Yes.
Okay. Awesome.
Yeah. So I mean,
Great.
I don't even know if I've written it down, but I definitely over time now I've come to start, I've worked with a number of lawyers who I would, some I'd recommend over others. And it's not to say that it's because we'll know we can take advantage of the other side. It's just because we know that they see the world and the transaction maybe similarly to how I see it.
A little more friendly to this type of thing.
Sure. Yeah.
Okay. Okay. That is huge. The last kind of thing I want to touch on is kind of the current landscape of the world right now. From your lens as a lawyer, we have, as realtors, I mean, we've seen, particularly this year, it's obviously everyone is operating at volumes that we weren't used to 2 years ago. And maybe in Calgary, we weren't set up for this level of business that we've done in the last 12 to 18 months. But I'd love to hear from you, just a general advice from a lawyer's perspective in terms of like timelines or things to be aware of right now when you're buying and selling real estate. Because I feel like people are running into issues, maybe because they're just not aware of how much time they need to do things. But do you want to kind of give us any sort of lay of the land right now?
Yeah, well, my best information is probably about the land title system from a legal perspective, right? And so I don't know how much people understand how land titles in Alberta works.
Explain that, please.
Okay,
I think that would be very helpful. Yeah.
So land titles, the land title system in Alberta is very good, and it's very good. It's one of the best, if not the best, in Canada and North America.
Okay.
Having said that, it's very slow too.
Yeah.
And it can be improved. And there is some efforts to make those improvements at the moment. But one of the reasons for the slow speed is that registration of documents goes, first of all, it needs to be original documents that we use. Okay, so wet ink documents must be, up until recently anyway, they were submitted to the land titles office. In other words, by courier. And what would happen is if it's a transfer of land, it basically, I try to describe it, it's not exactly this way, but it gives you a picture in your mind. It'll go on the top of a pile or the bottom of a pile, and that pile is probably this high. And there's some, I'm now being a little bit, but there's some old lady here at the typewriter, right? Maybe not quite, but and then she takes one off, and anyway, she gets to
It's
it
like in the
eventually, right?
movies.
That's right. So so it takes a long time, and the normal delay for that. So if I submit today, the normal delay would maybe be about two weeks to 3 weeks before I get a title back with the transfer completed, with Natasha's name on it. In the meantime, there's insurance in place to make sure nothing goes wrong and it doesn't slip off the top of the pile and lose its priority or somebody else get in. Anyway, and it almost never happens that there's a problem, but even if there was a problem, there would be insurance in place through lawyers and potentially title insurance, but mostly it's always through lawyers if we're closing on protocol. So that's most transactions. So so the normal delay is 2 or 3 weeks. Doesn't really affect anybody. The money transfers, keys are released. All of these things happen in the same day. And but now we're double the volume that we were last year apparently. And we just had I just was at a CBA or Bar Association meeting about this, and they were talking about it, and they were giving us some reasons that were provided by the government as to why, why the extra delay. And one is volume is at least double this year than it was last year. So they were caught off guard. Secondly, COVID restrictions have caused them so work from home has been an issue. Secondly, the isolation and other COVID requirements has also sort of slowed them down in terms of manpower. They also have had trouble increasing their numbers as well. They just haven't been able to increase their numbers again because of the dynamics of the COVID workplace and labor shortage and everything else. So all of that to say, we're at 9.5 weeks delay from about 2 currently. Does that matter? I mean, yeah, like it does in a few instances. Normally, like on a normal transaction and say an agreement for sale, it doesn't really, right? It just takes, you just need to know that you're not going to get a report from the lawyer for 2 months at least.
That's right. You gotta wait for that.
Yeah.
We have found it matters in new construction though.
It sure does. Yeah,
That's a totally different thing, right?
Yeah, and especially new condos, right? Because there's the Condominium Act doesn't allow for money to be advanced in any way. It has to be held in trust until that certificate of title issues in the buyer's name. Well, if that takes 9.5 weeks, what happens is we end up with tenancy at will. We end up taking possession in most cases. I mean, theoretically, you could still make it if the seller's lawyer gets me transfer documents 2 months ahead of possession date, and then I'm quick to get them. It's possible, yes. But that doesn't practically. That just doesn't happen.
Right. Yeah, so, exactly. That's what we've been finding. So, okay. Thank you for explaining that, because, well, and it's hard to know. I mean, like the regular consumer buyer doesn't know that this timeline has changed from a few weeks to 8 weeks, or does it affect them or whatnot? So always good questions to be asking your lawyer. Is there anything else that's unusual since COVID? Like maybe because the in-person signing and digital signing, that kind of has changed a little bit.
Yeah, that's actually one of the, I think, positives that's come out of COVID.
Will that stay?
I think so. Now, there's no, now don't quote me on that because it is not permanent yet, right? Yes. But I don't see how the temporary measures temporary amendments that they've made can be reversed from a practical perspective. I just don't know. I don't see the world going back so close to what it was 2 years ago that it justifies the reversal of this policy, which in effect not only allowed us to continue operating during COVID, and but also created a whole bunch of efficiencies, which are now becoming transparent. The fact that if you're not able to come into my office, if you're if you're not feeling well, or two, if you just can't make it, or it's very inconvenient. Yeah, if it's very inconvenient for you, then I could. That's right. So that I could meet with you by video conference to witness the signatures of the documents by video conference, just like we're doing now.
Exactly.
And then one of the things people have to realize is that it's still, there's a bit of a clunkiness to that process right now, because we still need original documents. So if you're signing with me in this meeting and I'm taking screenshots and we're doing the whole protocol, it's great, it's very efficient, but you still need to take those original documents and courier them back to me. And I mean, it works just fine. We do it all the time, but it's maybe consider just, it adds maybe a day or two to the process, right?
That's
Because
right.
you've got transit time or things like that.
Yeah.
But anyway, yeah, it's worked out really well for a lot of people and
Yes.
for a lot of lawyers. And I don't think that there'll be a reversal of that policy, but I guess
Yeah,
I've been
that would
proven
be
wrong
great.
before.
Yeah, well, that'd be great. I mean,
Yeah.
because it saves, because we do a lot of out of province work. So
Mhm,
it saves these buyers from having to have a local lawyer in their area to, you know, do all the paperwork and then have their Alberta lawyer and carry
That's right.
everything back. So you have,
Yes.
there's just less people involved and it's obviously quicker and you just don't need to leave your house. So
That's right.
so
Yeah.
that's great.
Yeah.
Awesome. I hope that's here to stay. That's
Mhm.
my hope too, for sure. Well, I think we'll wrap it up there. I mean, we covered a lot of different things. I'm going to provide Scott's website in the comments below, unless you have anything else to add. But
No,
you're available for real estate services.
Yeah, absolutely.
And happy to help. And Scott is a trusted resource of mine as well. So absolutely use his services, go check out everything he has to offer. And I really appreciate your time today.
It was a real pleasure. Thank you very much. Hopefully we can do it again.
Yes, absolutely. Maybe next time we'll talk about joint ventures or something else. We should, we'll choose another topic. Maybe that's a good idea. Let us know what topics Scott and I should talk about next, and we can do it again.
Sounds great.
Awesome. Thanks so much for your time. Have a good rest of your day.
All right. Thank you. Bye-bye.
Take care. Bye-bye.